Good morning, everybody. I'm Julie Ban, a partner here at Sharpe Minds, and this is our Sharpe Minds webinar on practical tips for defending disability discrimination claims and preparing for new obligations. We are recording this webinar, so if you have any questions, please do feel free to pop them in the chat function or the Q&A function, whichever suits you most, and we will get to them as the most appropriate time. If you need to or want to ask a question in person, I suggest you wait till the end. We'll stop the recording, and if anybody wants to actually speak to us directly, then please do so then. So today we are delighted to be joined by Safia Theroux and Orlando Holloway from 42 Bedford Row, who are assisting us in looking at this practical session on defending disability discrimination claims. But first of all, we are going to just look at where we are in the session. So if I can just ask you to move on to my next slide, please, Andrea. So as you'll know, over the last, this is our 5th month, we've run a series on disability discrimination, and we've covered the various issues to consider when looking at disability within the workplace. And your obligations as an employer. If you can move me on a slide, please, Andrea. So what effectively what me and the team have taken from the session, and we've been really helped enormously in terms of considering the themes by the number of questions and the engagement of people joining the webinar. But the first issue is in terms of knowledge of discrimination, and really the key theme, the key lesson learned, I think, in terms of that session was that an employer cannot wait for an employee to say or to tick a box to say that they're disabled before they action it. You have to take on board the information that you receive at a time, and the test is what you know or ought reasonably to know in terms of discrimination. Disability. The second is that if an employee does tell you that they are disabled or believe that they are disabled, and that could be a tick box as part of the recruitment exercise, it could be a tick box in terms of your ongoing information gathering in terms of employee data, then please don't ignore it, act on it, ensure that that information is considered, that discussions are taken with the employee, and that you consider whether you need to make reasonable adjustments. Moving on to the reasonable adjustments, it's really important. This isn't the obligation on the employee to tell you what they want. The obligation is on the employer to consider what adjustments are necessary. So I've had a recent case where an employee said that they had what would probably be defined as a disability, but they didn't need any adjustments. And the employer said, oh, okay, then that's fine. They didn't put anything in place. And then when things started to go wrong, the employee then argued that there'd been a failure to consider reasonable adjustments to enable them to remain in the workplace. So it is your obligation. Don't necessarily discuss this with the employee. Don't necessarily take their word for it. Ask them if they're willing to see occupational health, to see if there's anything else that you can do to ensure that you are putting them on an even keel in terms of their ability to play a productive part in the workforce with people that do not have a disability. And it's not one size fits all, it's fact specific. Don't just put in place the same adjustments you put in place for everybody else, because they won't necessarily be effective, and therefore they won't necessarily be reasonable. It's a balancing act. and therefore it's what's reasonable in the circumstances to enable the employee to play a productive part in your workplace. We looked at hidden disabilities and we are seeing an increasing number of claims in respect of hidden disabilities, either mental health issues or neurodiverse conditions and issues. We looked at how to spot it, how to consider it, and it is going to come down to that penultimate part. Communication is the key. So talk to your employee, find out do take into account what they think they need, but also do ask if they're willing to explore additional support. Use occupational health effectively. This is your opportunity to find out what adjustments you should be making within the confines of the role that they are undertaking. And so don't just send off to occupational health, this is what the employee does. Explain what you've already considered and why you can't do certain things. So if they can't work from home, please put that in your report, because otherwise what you will get is a report from occupational health saying exactly what the employee asked them to say, which is this person should work from home because it will alleviate their particular symptoms. So if it's not feasible, say that, and then the answer is either other alternatives or whether or not you need to consider an alternative role for them. And that comes to the home working, office work, and this has been raised so much since COVID. I would say. I mean, it wasn't a new when COVID occurred, but it's certainly something that we are seeing an increasing number of people requesting or expecting. So think about what the barriers are. It can't be a one size fits all. You will have policies in terms of what you require of your employees, but that is a policy criteria practice. And if someone has a disability, you have a duty to consider making adjustments to that to alleviate that disadvantage. David, do you want to come in there?
Yes, so we just had a question about is referring an employee or failure to refer an employee to occupational health in and of itself failure to make reasonable adjustments. And I said the use of occupational health itself isn't, because that's not the reasonable adjustment. It's a portal to get you more advice on what reasonable adjustments you should be considering. It's not a requirement to send someone to occupational health. You can do it yourself with discussion with the employee or off your own volition. So an employee can't say it's a failure to make a reasonable adjustment because you didn't send me to occupational health. It just might make it harder for you to defend a claim for making failure to make reasonable adjustments if you didn't use occupational health to support you to get a further idea of what support might be in. So the specific use of occupational health itself wouldn't be, because it's not a reasonable adjustment to get someone back into work itself. It gives you those reasonable adjustments or gives you a chance to look at them. So I think I would still say use occupational health. It's a great source of independent advice or support, but its use itself won't be. Or lack of use, I should say.
Yes, the only way that you could run that as a breach of the obligation is if the employee said the failure to go to occupational health was a policy or criteria, a PCP, so a policy or criteria practice. So you as an employer had a practice that you never referred employees to occupational health. This put me at a substantial disadvantage because of my disability. I required that additional support to consider what I needed in the workplace, so they could try and run it that way. I mean, ultimately, if you don't obtain medical evidence to see what adjustments should be required, you may be failing in your obligation to consider them in the first place, and so it's just an indicative of a lack of the thought process rather than anything else. But if you've already got ample medical evidence from the GP or from other sort of assessments that they've undertaken that say what the adjustments are that they need, it may be that you don't sending them to occupational health isn't actually going to add any value, and so that it's fact specific, I would say. There are risks of getting it wrong. Obviously, the key risk is an employment tribunal claim, but the other risk is that you, as an organisation, should be and will be considering yourself as disability friendly, and if you are not considering how to accommodate employees with disabilities in the workplace, then you that's something that you're failing to do, and you will struggle to retain those key staff that can play a very important part in your working environment. So there are two things: the financial and reputational risk of a tribunal, and the reputational risk of just not managing or supporting employees in the workplace. So that is the key themes that I think that we've got out of this session. If you can move me on the slide, please, Andrea. So I am going to pass over now to Safia through, and Orlando Holloway from 42 Bedford Road, both experienced employment practitioners working across both claimants and respondents, and covering a range of client types, and so we'll have huge amounts of practical experience on what they've seen that has worked and what doesn't work. I'm not going to presuppose what they're going to cover here for you, but I'm sure it'll be practical and fantastic. If you've, as you say, if you've got any questions, please keep asking them, and we'll see if we can answer on the way. So I'll hand over to you.
Thank you very much, Julie. That's lovely. Yeah, so you can see there a little bit of a biography of both of us. I mean, the shorthand really is that, and I don't want to tar Safia with the same brush as me, but really we're both the same call. We've been, for the last 20 years, sometimes in the Court of Appeal, quite regularly in the Employment Appeal Tribunal, but most of the time has been in the weeds of the Employment Tribunal world. And we're basically there all the time arguing these sorts of points, for better or worse. So that's where we come from on all of this. Andrea, could I ask you to move on to the next slide, please? Thank you very much. So you see there the focus of today's session, and what we're going to do is that I'm going to talk about the case management stage and then preliminary hearings. And then I'm going to pass over to Safia, who's going to talk about the other 3 points there: matters arising before the final hearing, practical issues at the final hearing, and then exploring the question of how do tribunals assess reasonable adjustment claims in practice. So, Andrea, if you could move me on to the next slide, please. That would be great. Thank you very much. So what we're going to talk about first of all is effectively the first question about disability claims, which is the question of whether to concede or not to concede the issue of disability itself. So what happens here is that you'll have a claim in, obviously, that either sometimes has just ticked the box of disability or has had a stab at explaining what the disability claim is. Now, a lot of claims that you'll receive will be from litigants in person. Some will have had professional representation in preparing the claim form, the ET1. Now, at the risk of sounding overly cynical, I'm afraid quite often I see claimant solicitors haven't necessarily done a very good job of that anyway. So even in those cases, you can see the same problems as litigants in person do provide. And those problems particularly are that employment tribunal and employment law, as you will have come across, I expect, over the last few weeks, is pretty complicated. And it's quite complicated for professionals, and it's very difficult for litigants in person to get their head around. And disability discrimination is one of the more complicated areas. So what one very commonly sees with litigants in person is, for example, the claim form will say, this is what the employer should have done by way of a reasonable adjustment. They might have got that terminology from somewhere, but it won't have gone through the stages you need to get there in terms of identifying the PCP and the disadvantage, and then the adjustment that's contended for. And that vagueness can go right back to the question of which disabilities are actually being relied upon. Now, obviously, there will be the opportunity to put in a grounds of resistance, and there are different ways of doing that. And depending on the precise circumstances, sometimes it's worth exploring in the grounds of resistance the areas where further information might be required from a claimant. But often, actually, that can be a danger, and giving them that opportunity to provide a lot more further information before the first preliminary hearing. But what you can be confident is that in almost all of these claims, there will be a preliminary hearing at an early stage. Now, I use early in the sense of the process of the litigation rather than quickly, because as you may have come across already, I'm afraid the employment tribunal system is groaning. And if you're in Croydon, then the early preliminary hearing is going to be a year after the claims come in, probably. And I'm afraid there's not much we can do about that, but that's a bore. But so what will happen then is that at some point there will be a preliminary hearing. Typically it will be by video, might be a couple of hours long. And when the listing comes out, sometimes these sorts of claims are ones where you want to say straight away, actually, we're going to need a bit longer on this because there's so much we need to work through because of the complexity about disability discrimination claims. But for the purposes of what we're talking about today, that hearing is a really, really important one for setting the agenda for the litigation going forward. And that's both in the broader context of looking at what the reasonable adjustments claim or what the something arising from disability under a Section 15 claim or whatever it might be, establishing all of those different elements, but even going right back to what the actual disability relied upon by the claimant is. And the common problems here that one sees are, firstly, sometimes they just won't say at all, and then you're completely in the dark. Sometimes they will very broadly describe a disability, but perhaps by reference to the impact, or they might say something like mental health issues or something like that, very broad questions. And sometimes they will list a whole load of co-disabilities in circumstances where actually a number of them may be completely irrelevant to the question that's being decided. So, for example, if someone has diabetes, but actually it's completely controlled by medication, has no issue at all in terms of their working life, it's still gone on the form, but that isn't relevant to the claim that you're going to be determining. So it's at that first preliminary hearing that you really need to drill down into those questions, and it's usually better to do it at that preliminary hearing than to try and do it writing in advance, because at the hearing you'll have the representative for the respondent who'll be able to marshal the questions that they need answering to understand the claim, and the judge will also be able to put some sort of sense check on the claimant. The context of all of this obviously is that unfortunately it's very, very difficult to have claims of discrimination struck out at an early stage. So the exercise here, frustrating though it may be, the EAT has made it very clear the exercise is identifying properly what the claims are at this early stage, not trying to get bits kicked out, because other than in certain limited circumstances, it's very, very difficult. But so at that hearing, it'll be an opportunity to really work through the exact disability relied upon and the broader claims that will also allow you to identify the relevant period. So what are the disabilities being contended for, and what timing do the claims rely on? And then you can then identify which period you need to determine whether or not the disability applies for. So that's the information that you'll be looking to gather at that first hearing. Now, obviously, relevant to how all of this is dealt with is what knowledge the respondent already has about disability. And we've got a few points in the slide there about things that an employer will or may know already. So there is the other point, which isn't in this list, which is that sometimes in a very obvious, sometimes disability will be very obvious physically. And in those circumstances, obviously, the respondent will need to be aware of what their knowledge is on that point. But even where that isn't the case, they may have evidence from the original questionnaires. They may have things from the GP during the course of employment, sick certificates or whatever it might be. And often there will be some occupational health reports. Now, that isn't to say that any of those things necessarily will determine how you defend the disability claim, because it can be good practice to have made the assumption that someone is disabled and to have proceeded on that basis. And that isn't necessarily the same as saying that you need to concede it at a tribunal. But obviously, in circumstances where, for example, the occupational health report has recommended that someone is likely to be disabled, there will need to be a pretty good reason why you're not conceding disability in that case. Now, those do come up from time to time. Safia and I, and I'm sure the Sharpe Pritchard team have seen cases where occupational health have made a complete horlicks of advice and pronounced that someone's disabled when they've entirely misunderstood the situation. So it's not absolutely determinative, but you need to be really carefully going through the test before you say, actually, I'm not going to make a concession based on an occupational health report that has recommended that such a concession is made. So the final point there is about the caution that you need to exercise before disputing disability, if that's going to be unreasonable, and that feeds back into what I was saying. And I've noticed, and I think Safia's had the same experience, that in the last few years, tribunals have been a little bit firmer with respondents about this, at these early stages, in saying effectively, oh, what really, you're disputing disability in those circumstances, and putting respondents on notice that if that's a position they maintain, that there may be some issue about costs or so on. That said, I've heard it said a few times. It may just be because generally respondents then go and take the right steps after that. But I haven't been involved in cases where there have been any orders that have resulted from that. So again, it doesn't necessarily mean that you need to take on board what a preliminary hearing judge says in the first instance. You need to assess what the tests are, depending on the evidence you've got at different stages. Okay, Andrea, could you move me on to the next slide, please? Okay, so now we've got a few points about the preliminary hearing and whether or not you're going to be having one to determine disability. So if we're in a situation where at the first preliminary hearing, there will be a discussion about what the respondent's stance is on disability. Now, the directions that will follow, typically, if you say you're not conceding disability, are that the tribunal will order the employee, the claimant, to provide their medical evidence that's relevant to the question of disability and an impact statement where they set out the substantial adverse impact on their day-to-day activities. So the order will usually be for those two things to happen. And then for a period of time, perhaps 14 or 21 days thereafter, the employer will set out their position on disability. And so sometimes the disability will be conceded. If it's being conceded, it's important to be quite precise about what the concession is. And sometimes you just see a concession where actually it's important to be clear about what actual disability is being conceded and for what period. If there is a dispute about the question of disability, then that is the opportunity for the employer to explain the basis on which they dispute it. So typically what you'll be talking about there is that there is that the substantial adverse impact, that there wasn't a substantial adverse impact on day-to-day activities, or that there wasn't that substantial adverse impact wasn't long-term. Those are usually the two arguments that are being made, but you'd need to be clear about which of those or what other points are being taken in respect of disability in the response. So that we're in a situation there where there is a decision has been taken not to concede disability. Whether or not to have a separate hearing is in fact something that you'll often need to decide at the earlier preliminary hearing before you've had the claimant's impact statement and medical records. Because what you will then need to do is you'll either be saying that we don't concede disability, but we'll leave it to be wrapped up at the final hearing, or you'll be saying we don't concede disability and we'd like a separate preliminary hearing to determine that point at an early stage. Now, you can then decide, if you're going for the preliminary hearing, you can say, well, we'd like that listed now, or you can do a hybrid where you basically say, well, we'll see what the position is, and if we think we need to have a separate preliminary hearing, we'll make an application for that hearing after we've had the claimant's medical evidence and impact statement. Now, usually it's better off to get the hearing in the diary and then pull it out if you don't need to because of the practical difficulties. Now, in terms of whether or not it's worth having a separate hearing, that will essentially depend on usually on how strong your arguments might be on it, and also how much of the claim it's going to get rid of. So in circumstances where you only have a disability claim, then you frankly, if you think you've got a shout at it, you might as well have a go early, because it will save an enormous amount of time and money running the defence of that claim. So even if the odds aren't amazing, better off having a crack at a preliminary hearing at an early stage. If it's a disability discrimination and an unfair dismissal claim, then again, unfair dismissal tend to be much shorter and easier to deal with than disability claims, so you might think it's worth having a preliminary hearing on that. If it's actually disability and race and whistleblowing and they're all completely mashed up together and it's going to make no difference getting rid of disability in terms of the length of the final hearing, then you might think, well, it's just not worth trying to get rid of that at an early stage, so we won't bother. At the preliminary hearing, you will usually just have evidence from the claimant. So the claimant will give evidence based on their impact statement. Sometimes they might call a witness, a family member, who can talk about the impact that the alleged disability has on their day-to-day activities. But normally it will just be them. Very occasionally you can call evidence from the employer. And that is essentially, I did see it sometimes where the employer can say, well, we don't agree with this impact on day-to-day activities because actually of the job this person was doing required them to do all of these things all of the time, and they never raised any issue about it. So it's quite rare, but sometimes you might lead some evidence, either a witness statement or perhaps some documentary evidence about what they were doing. But it's generally fairly rare. Now, the other thing to bear in mind about those hearings, so by this stage you will have had the impact statement, the respondent would have been very clear about what they are disputing in terms of which elements of the test. The claimant will give their evidence. Often impact statements aren't very good, particularly if it's in person. They don't really address the right points, they don't deal with the right periods, they don't deal with the substantial adverse impact on day-to-day activities. Now, in other jurisdictions, the witness statement's what matters, and you could, as a respondent barrister, you could not ask any questions about it at all and just say, well, you haven't proved it. Now, that tends not to work in the employment tribunal because, as this slide mentions, judges get quite inquisitorial about this, so they often will descend into the arena a bit and start saying, well, come on, tell me all about it, tell me what the real problems are, and so on, which can be a little bit frustrating, but that is the way it operates. So you just need to be conscious of that when defending those elements of the claims. And so that is a situation where my own broad view is that provided you think you've got legitimate arguments about the disability claim and disability status, that actually, although the law makes it look very easy to, well, not very easy, but quite straightforward, generally it's quite a low hurdle for claimants to pass the disability threshold. Actually, in practice, some judges can be a little bit more cynical about it. So I've run cases where we've had a successful result on disability, which looked pretty unlikely, but we thought it was worth a go. And sometimes you get better results than expected. So as long as everybody goes into it knowing that you might get a judge who's a little bit irritated that you're even taking the point, but on the other hand, you might get a judge who goes for it and it's worth the risk, then you can sometimes get benefits from approaching it in that way. So, Andrea, if you take us on to the next slide, please. Thank you very much. I'll pass you over to Safia.
Thanks, Orlando. So we're now going to move forward in time, as it were. So we've identified what the claims are that the individual has brought. We've identified what the disability is. If we needed a preliminary hearing to determine that, we've dealt with that. And we're now preparing for the final hearing. So I'm going to talk about this in two stages. First, in terms of preparation for that final hearing itself, and then what actually may happen during the final hearing in the context of an individual who has an accepted or recognised disability. And the first thing to think about from the claimant's point of view and also the tribunal's point of view is what adjustments does this particular claimant need in order to effectively take part in the final hearing? Because it's important to remember also that the tribunal, as an organ of the state, also has a duty to make reasonable adjustments to ensure that the individual can effectively take part in that hearing. And in terms of what those adjustments might be, the array is quite significant. So it may be something like an individual isn't able to travel to the tribunal, and therefore they need to have a hearing that takes place via video. It may be that an individual says, well, actually, I have anxiety and depression, and I therefore need more regular breaks than usual. Now, these are the sorts of things that can sometimes be dealt with in advance at a preliminary hearing stage, where as part of the questions that are asked, the judge will say to the claimant or their representative, are there any adjustments that the claimant needs? And if they are of the type that I've mentioned, it may be as simple as saying, well, we'll note those down, and when we get to the final hearing, the judge will be aware of those, and they may start the hearing by saying to the claimant, well, I understand you need more regular breaks. Please let us know how often you need them, or let us know as and when you need a break, if it may not be as simple as saying I need breaks every X period of time. Sometimes it can be a little bit more complicated. And on those occasions, either a judge may flag at an earlier stage, or there may be an application made at some stage before the final hearing where a claimant via their representative or individually may say, well, actually, here are a list of all the things I need. And it may be appropriate in those circumstances to have a separate hearing before the final hearing to actually consider that application or those adjustments that are being required in order to decide to what extent they'll be accepted. Those hearings are often called ground rules hearings. It's a concept that those of you who may have been involved in criminal proceedings at any point may be familiar with. It's becoming slightly more common in employment tribunals, I would say, particularly where claimants are asking for sometimes quite significant adjustments, especially in our experience in cases where claimants are relying on ASD type disabilities. And the reason for that is because the sorts of adjustments that they are asking for can be very significant in terms of their impact on the tribunal process as a whole. So you may have a claimant who has some form of autism spectrum disorder who will say, well, actually, I find it more difficult to spontaneously answer a question that is being asked of me. And therefore, I need additional support with that. Now, at one end of the spectrum, it may be that they say, I need to be able to have pen and paper in front of me to be able to make a note of that question, and it may take me slightly longer to answer. And that needs to be taken into account so that the tribunal doesn't take the view that just because there's a slightly longer pause or a delay before the answer comes, that has any potential impact on the credibility of what is being said. It may be, though, that a claimant says, well, actually, I'm going to find the process of being asked questions about lots of different things quite challenging. And so I need a list of the topics that the questions that are going to come in cross-examination are going to relate to. And I need that list in advance so that I can be prepared for what is going to happen. And I will know the order in which those questions will be put to me. Or a claimant may say, I'm going to struggle to deal with questions put to me in advance, even if I know what those topics are. And therefore, actually, what I need is a list of all the questions that I'm going to be asked in cross-examination to be provided to me, say 14 days in advance of the hearing, so that I can reflect on those and think about my answers, such that I'm then able to effectively answer those questions in tribunal. And it's in those sorts of cases where we're talking about these quite significant adjustments, where often there will be a separate hearing in advance in order to decide to what extent should those adjustments be permitted. The other interesting adjustment that we've seen as well, which is linked to all of those, is that a claimant may say, well, I may need some adjustments to the questioning process, as I've described, but I also need to be able to record the hearing because I'm representing myself. I don't have anybody else who can make a note with me, and I can't, and I need to know what's being said. So I need to have the ability to record the hearing so that I can then review what is being said or what was said during the course of the day. And of course, we know that recordings generally are prohibited in employment tribunal proceedings. So that's, again, a significant adjustment. Now, what's really interesting and important to be aware of in this situation is that all of those types of adjustments could conceivably be granted. And Orlando and I have had cases where some or all of them have been. but the extent to which they will depend on, in our experience, the medical evidence that is provided that can justify those adjustments. And what the tribunal will be looking at, particularly where individuals are asking for things like all the cross-examination questions in advance, is the extent to which that is really necessary, and or whether there may be other less significant, shall I say, adjustments that could be made that could assist or alleviate the disadvantage that the individual will suffer without necessarily going to that stage. So it's important to be aware of the sorts of things that might arise in order to determine whether actually a separate hearing is required, because often these sorts of hearings do take some time to deal with, given that evidence will be required, medical evidence needs to be considered, etc. And so it's not always a good idea just to wait until the final hearing, particularly where individuals are asking for things like adjustments to the cross-examination process, because if that is necessary, then clearly that needs to happen well in advance of the hearing itself. So moving slightly forward then to the final hearing process, a few things to flag in relation to that with respect to a disability discrimination claim and a disabled claimant. Some of you may be familiar or have heard of what is known as the Equal Treatment Bench Book. That's a book written for judges, and a key part of that is to provide them with advice and information in respect of how they are supposed to then deal with cases in this context of disability discrimination. And that then often influences the manner in which they conduct the hearing. So particularly the judge will handle the hearing. And it's important for respondents to be aware of that guidance, because sometimes it can feel, as a respondent or as a respondent witness, that the judge seems to be bending over backwards to support a claimant, particularly a litigant in person, to be able to get through the final hearing process. And sometimes, to put it bluntly, respondents feel that that's a little bit unfair. And it's important to be aware of those, because there is clearly an obligation on the tribunal to ensure that a disabled claimant is able to take part and access the tribunal process. And sometimes that does mean making additional adjustments for them, or allowing them extra opportunities to do things, or giving them more time than was agreed, for example. And those things will happen during the course of a hearing in a way that, as I say, sometimes may feel slightly unfair. But it's important to be aware of and to remember that what the judge is trying to do is to ensure that the claimant can take part effectively, such that whatever decision is made, whether it's in the claimant's favour or the respondent's, or sometimes, as we often find, a bit of both, that is a decision that a claimant then cannot challenge by virtue of the fact that they say, actually, I wasn't given a proper opportunity to take part in the hearing, and therefore any conclusions that arise from it need to be set aside, because the hearing needs to happen in a way that is more appropriate in order to allow me the best possible opportunity to be able to put my case. The last thing any respondent wants, I'm sure, is to have a hearing that has taken place, potentially quite a lengthy hearing, need to happen all over again from the beginning. And so in those circumstances where a judge may, for example, say, well, actually, you have this period of time to cross-examine the respondent's witnesses, and a claimant, for whatever reason, says, well, due to my disability, it's taken me longer than I thought, and actually I need longer. It might be frustrating if a judge says, well, actually, okay, I'll give you a little bit more time, for example. But ultimately, the aim is to make sure, from the respondent's point of view, that the hearing has given the claimant that fair opportunity, such that whatever the outcome is, it's one that can't be challenged on those grounds. So moving forward then to the next slide, we've talked about the process, Orlando and I, at different stages. The last thing we were considering looking at in a little bit more detail in relation to our practical experience of defending disability discrimination claims relates to reasonable adjustments claims. And that's essentially because, as we understand it, this is an area where there were a number of questions and queries from those of you who've been attending this series of webinars. And we are also conscious that it's an area that clearly often raises questions, queries, and sometimes confusion as to how tribunals actually deal with these types of claims. So I'm going to briefly run through a few of the key issues that we see in practice when it comes to these sorts of claims before we open it out for questions. And I'm conscious that we have a few more minutes before we need to move on. So some of the key things that we see that it's important just to think about and flag when it comes to actually defending these claims in tribunal. First of all, is actually what is the PCP that is being referred to? And I'm thinking not so much in terms of the cases where a particular physical issue is identified, but actually where it is something relating to a provision, criterion, or practice that the employee is said to have put in place. And this is important because in a lot of reasonable adjustments claims, as Orlando mentioned right at the very beginning, claimants or their representatives may not have actually thought about what is the PCP and may simply have jumped to what are the adjustments that the claimant wants. But sometimes when then having to work backwards in looking at what is the PCP, they sometimes focus on something very, very specific that related only to the way that they were actually treated and hope or think that that might be enough. And what's important to be aware of is that a PCP, as you may well be familiar with, is something that doesn't just apply to the individual concerned, but actually is something that the employer has or would apply to everyone. So if, for example, an employee says, well, you delayed the hearing of my grievance, and that then caused me unnecessary or anxiety or exacerbated my anxiety symptoms as a result. And then they set out the PCP as unreasonably delaying the disciplinary process. Well, it may be that the employer has such a PCP, but the tribunal are going to have to be satisfied that this was something very specific, this was something that was not very specific to the individual, but was actually a wider issue. And if the tribunal isn't satisfied of that, then it may be that the claim simply fails at the first hurdle, because if there isn't such a PCP, then they cannot really go on to look at all the other issues. And even if they do, it doesn't particularly help the claimant. The second part of the test, as you will know, is that the claimant needs to demonstrate that the PCP in question actually caused them substantial disadvantage. And again, this is something that claimants often don't really think about. And it may be the case that the individual can give some evidence that says, well, this is how it caused me substantial disadvantage. But more often, they will need some link to the medical evidence or some other evidence that demonstrates that actually their particular disability resulted in them suffering that substantial disadvantage as a result of the PCP. So to just give you a really simple example from a recent case that I was involved in, an individual who said that they had autistic spectrum disorder in that case said they struggled to deal with being asked questions on the spot, which was a normal part of the way that training for that particular role was undertaken. But there wasn't any evidence in any of the occupational health reports or the medical reports or the diagnoses reports or anything that suggested that this was an individual who actually struggled with that type of questioning. And there was therefore an evidence heard as to, well, what is the basis of the claimant saying that that caused them substantial disadvantage over and above, of course, them thinking that it did, and the fact that they said that they struggled with those. So again, that's something to think about. Looking then at the suggested adjustments, it is often the case that the claimant will list a number of things which they say that the employer should have done. And an employer will then look at those and have to consider to what extent can they defend those particular adjustments. But what's important also to flag is that there isn't a specific obligation as such on a claimant to list all of the adjustments that they think should have happened. And it's only for the tribunal to look at that list, because the tribunal are able to, somewhat unusually in an employment situation, actually consider for themselves what they think the adjustments could have been or should have been, even if they don't necessarily feature in the list that has been prepared in advance of the hearing. Because ultimately, the aim of these provisions is to consider how is it that the individual can effectively undertake their role, and what adjustments may they need in order to be able to do so. And even if they haven't thought of a particular adjustment, but the tribunal come up with something, that doesn't stop them from actually considering it. And then very finally, before we move on, this concept of reasonableness is one that people sometimes find somewhat difficult to get their heads around. And that's understandable, because it's a little bit more difficult perhaps to specifically pin down what is reasonable, and to be able to identify and say, well, this falls on this side of the line and a different adjustment falls on the other side of the line. But ultimately, it's a balancing exercise. It's about looking at what assistance would this particular adjustment provide to the individual, to what extent does it alleviate that substantial disadvantage. And that's important, because an adjustment that may be significant but doesn't really change things substantially may not be reasonable. Whereas an adjustment that is being sought, which may directly assist, will inevitably be more likely to succeed. But on the other side, of course, there is also the extent to which it is reasonable for the employer to do these things. And that will look at things like cost. That could also consider the actual impact, not just on the individual, but on the wider team and on other individuals within the organisation. And it's about balancing all of those factors in order to determine to what extent is something reasonable. So if, for example, an individual says, well, I can only do 30% or say of the issue, the particular elements of my job description, because the others are causing me significant difficulty as a result of my disability, and therefore, as a reasonable adjustment, you should take all of those away. Now, it depends, of course, to what extent that is feasible. What is the impact going to be on the other members of the claimant's team who would have to pick up on those other things? Are there things that the claimant can do instead to assist their other colleagues, for example? So all of those issues come into play in deciding whether or not an adjustment that is being sought is reasonable or not. And it is a very practical exercise in looking and balancing all of those factors before the tribunal will be able to come to their view. So I'm going to pause there and Julie, hand back to you. But if anyone does have any questions about anything that Orlando and I have raised, then please do raise them, and we'll be more than happy to answer them and discuss the queries that you have.
Thank you, Orlando. Thank you, Safia. I think that was really helpful and real practical focus on looking at tribunal claims. And this issue of reasonable adjustments comes up so often in terms of how we defend claims. There's quite regularly you'll see we have a lot of litigants in person. Quite regularly they will put down all the adjustments they want that have absolutely no bearing on the PCPs that they have put in place. But I think one of the key points that I take away from your talk there, Safia, was this idea of having evidence of the substantial disadvantage. Because I've often found employment tribunals, like as Orlando said at the beginning, it's not in terms of defining disability that, you know, there's substantial long-term impact on the day-to-day activities. If they've made a finding that the person is disabled, or you've conceded that, then the substantial disadvantage often goes hand in hand with that. And so we haven't often interrogated that element of it, but I think that's something that we should take forward. So that's been really useful. So thank you for that. If anyone, as I say, any more questions, please do pop them in. So we are going to just, if you move me on to the next slide, please, Andrea. There you go. That's the details. You will get these slides out as well, everybody, so you can get those details down and we'll provide those to you. The next slide as well, Andrea, please. So we're just going to cover a few brief topics. The first is, and it's been highlighted throughout the different talks this morning already, we are finding a growing number, our practical experience is a growing number of tribunal claims under disability discrimination that refer to hidden disabilities, mental health, neurodiversity, issues that are difficult to define. Long COVID has come up a number of times relatively recently. And I think that it's a really good thing for employers to do is to take stock and to consider your internal guidance, to consider how you actually support employees with mental health conditions, if you need to adapt absence performance processes on a fact by a specific basis, your return to work procedures, and looking at where there's any other elements within your absence management process, if nothing else, that could reduce the risk of discrimination claims. And ultimately, when it comes down to it, if you're looking at reasonable adjustments, you really need to document carefully, have some sort of contemporaneous record. If you're not able to make adjustments that have been requested or recommended, you're setting out very clearly why that is the case, and you're always looking at for compromises. And I think it's really useful to show that you have done that at the time, because as Orlando said, once a claim gets into the system, it could be a year before you have the preliminary hearing. It could be a further year on that until you have the final hearing. By that time, the claimant's view as to what was required and that type of thing will have changed dramatically, and their witness statement will cover all sorts of different things that they hadn't even contemplated at the time, and neither had you. And so I think it's really useful to make it really have those sort of records in place so you know what happened and when. The second thing that I want to cover is the Worker Protection Act that's coming into force in October 2026. As you know, we already have the Prevention of Sexual Harassment in force, and this Act intends to introduce a new preventative duty on employers to take reasonable steps to prevent harassment, and in particular for this topic, disability, harassment related to disability. So, we've got till October 2026, so you've got a really long time lay in here, but actually starting to think about how you're going to plan for that, what measures you can put in place, what proactive measures you can put in place, what campaigns you can undertake to show the different support measures that you have in place to ensure that people are aware exactly what is expected of them before that comes into place. You've got that time frame to think about it, but it is worth starting that at an early stage. Next slide, please, Andrea. Okay, so we have gender pay gap reporting. We've recently had the Employment Rights Bill. I think it's the Employment Rights Bill. It just says the bill, and I don't think it's the Employment Rights Bill. It is the Ethnicity and Disability Pay Gap Reporting Bill. Pardon. Has just been out for consultation in terms of how that will operate. The consultation ended, I think, on the 10th of June. We're not expecting this to come into force until next year at the earliest, but the proposal is to extend the pay gap reporting obligations to include ethnicity and disability for employers with more than 250 employees. The proposals currently in terms of disability reporting are to do so on sort of a binary level. Employees that do not have a disability, employees that have a disability. So you don't need to focus on any particular types of disability, etc., because that's just a never-ending spectrum. The information that you have to use to analyse your data is that which has been voluntarily provided by your employees. By that, I mean if you have your employee information forms that set out, do you have a disability, do you not, what your ethnicity is, that type of thing. So it's voluntarily provided by them. However, if someone voluntarily provides you that information in another format, then you should be recording it for the purpose of this. Now, as I say, it's still at proposal stage how it will happen, but there are a number of employers that have already voluntarily started doing ethnicity pay gap reporting. And you will also be aware of the publicity, the media reports when people produce their gender pay gap reporting to ensure to see that there is a level of interest on a public level in terms of when these reports are produced. You've therefore got this opportunity now to start thinking about, even to run, to look at the data that you do have in place now, to see whether it actually is sufficient for you to run an accurate pay gap reporting in terms of disability analysis. So look at the information you've got. How many employees are not completing that data, and what do you think the reason for that is, and what can you do about that? And more importantly, how many employees are ticking the box to say they prefer not to say? Why could that be, and what can you do about it? Because I think it's good opportunity now to do some sort of campaign to show how seriously you take equality and diversity in the workforce, to confirm what if people complete that information, what you are going to use it for. It's going to be used for positive change in the workforce. It's going to be used to complete these reports so you can put together an action plan as to what you're going to do to improve the working practices for people that have a disability. The other proposal in terms of this bill that is slightly different from the gender pay gap reporting bill is there is a proposal that you will have to put in place an action plan as to what you're going to do. And so just getting to grips with these things, ensuring your data is correct, think about a campaign. I've seen other commentators say, and I think it's a really good idea, that campaign shouldn't be run by HR. It should be run by somebody that has credibility within your organisation to show how seriously you consider that. And I'm not saying HR don't have credibility, so I apologise if that came across in that way. Obviously you do, but it needs to be a senior level leadership focus to get that information in, to ensure that when you do your reporting it is accurate, because then you put together an action plan to rectify or alleviate any pay gap. Finally, our anecdotal evidence, and that's Sharpe Pritchard focus. We have recently in disability discrimination claims. So over the last few years, we've seen, we have advised clients that have come to us with a disability discrimination claim going, oh, right, whatever happens here, tribunals are going to try and look for something to give to this. So it might be just a random, you failed to make a reasonable adjustment for 1 week when you didn't give them a chair that they want. So that sort of, they're going to try and find something to find against you. And we've seen it a bit more of a shift in recent cases with more pragmatic decisions on knowledge about disability, on what is reasonable in terms of adjustments, in terms of practical effectiveness of adjustments that are being asked for. That is not to say that tribunals don't take it as seriously. It's not to say that that the risk doesn't remain, because it does. I think they're the most complicated cases to run for both claimants and respondents, and there's always a risk there because a lot can bear on the witness evidence on the day. As Orlando said, the way the employer conducts a litigation, we believe, can have a bearing on the tribunal's perception of the case. if you're really robust and almost aggressive in how you conduct or defend disability discrimination proceedings, if you defend every element irrespective of the strength of your argument, it doesn't look like you're an empathetic employer, especially if that individual remains an employee. It may have a view on their perception of how reasonable you are in terms of when you've considered adjustments. So it can have that sort of knock-on effect. Injury to feelings awards are not intended to be punitive, but we think the value of awards is increasing in terms of injury to feelings awards for one-off acts or failures to make reasonable adjustments. I'm not suggesting they're going to be significant, but actually you could have run a whole claim that covers 20, 30 different allegations. The claimant could win on one and come out with, £5,000 to £10,000, and it's all, a huge amount of money and a huge amount of time and a huge amount of effort then to rectify the employment relationship if the employee is still with you. So you need to think about the stepping stones, as we've said, to put in place measures to address and prevent risks. I think I've got a little red dot on my Q&A. I don't know if that means I've got a question. Bear with 1 moment. I'll just have a quick look. Yes, a couple. So we find occupational health reports more on what the employees say to the assessor rather than their actual disability and context. How can we make see more? No, do you know what? I think the difficulty often is, and we see this a lot, that the employee goes into, certainly people that are the hidden disabilities that aren't quite as much harder to assess for anybody. The employee goes into occupational health and says, this is how I feel, this is what's happening to me. Often say I'm being bullied, I'm being pressured, all those sort of things. It's all written down in the report as fact. And then the occupational health practitioner recommends everything that the claimant has, that the employee's asked for. And we do see that quite a bit. And so the first thing is to ensure that, as we said earlier, put in there what you can and cannot do. So you're asking for recommendations within that boundary. And the second is, if you get a report back that you feel hasn't really explained how they've reached the recommendations or whether they've taken into account the context, you can go back, to the occupational health advisor, and you can question that. You can just say, look, thank you for your report. We just want to clarify this. We told you this is the context. You've come back with these recommendations. It isn't clear how you've taken that into account. Can you just clarify that? You're not suggesting that you're not going to make recommendations. You're just trying to find out information to make sure it's accurate. The other is, as an organisation, take a general stock of the service you're receiving from occupational health, and if you're finding that they are not giving pragmatic advice that is workplace, medical, environmental, pragmatic, practical advice, then you source an alternative, and because you're staying with the same people that are providing the same basic service that is really unhelpful, isn't going to assist going forward. I think that might be the only question we've got. Thank you all for staying with us. Thank you again to Orlando and Safia for joining us. Really enjoyed your input today. If anyone's got any questions that they didn't feel comfortable asking in front of everybody, please stay around. Otherwise, if you could just move us on to the next slide, please, Andrea. So our next series, it says July 2025, but I think we're having a break in July and August. We usually do. So the next series coming up, and we will send you the dates for it. We're going to do a TUPE series. So we're going to run it similar to the series we've done on disability and have several sessions just looking at the various elements of TUPE. If you've got any other topics that you think would be useful for you, you're going forward, then please do get back in touch with us and let us know what you'd like us to cover later in the year. But thank you again for joining us. Thank you again for our colleagues from 42 Bedford Row, and have a wonderful afternoon.